So House Bill 9, this bill requires the Department of Human Services to post on its website a free online course on the identification, prevention, and reporting of child abuse.
I thought this had to do with all the crappy reporting that's going on. We could get some improvement. That's all this is. Okay. I'm disappointed. That's all. Second.
All right. Everyone okay with that? Excellent. All right. So, do you want to do this House Bill? Yeah. Yeah. All right. All right. Do we do direct 39, House Bill 39?
Yeah.
Is that you?
Yeah.
Let's go.
So House Bill 39, this is a cross-file. It's identical to the bill as passed by the Senate. However, it was not unanimous. In JPR, there were 3 nays, Senators Castley, Bailey, and Huff. And then the bill passed the floor 34-13. So this is the bill that requires a court on motion by an individual who has filed for an action to change name under Maryland Rule 15-901 to waive the publication requirement set forth in the rule. Currently under the rule, unless the court on motion of the petitioner orders otherwise, a notice must be published one time in a newspaper of general circulation.
Josh, House Bill 23, Delegate Stein. Oh, sorry. No, I was just saying this is the list you have before you, just stuff that either passed unanimously or overwhelmingly, but it's not on a partisan basis. That's all.
So this bill doesn't fit that description, but it modifies the Public Information Act to require an officer, employee, agent, or contractor of the state or a political subdivision to deny inspection of specified records and to deny the use of facial recognition searches by.
I see is it the cross-file to Senator Lamb?
Correct.
Okay, got it. Let's hold off on that one for now. We'll come back to that. Got it. All right, we'll go to. So what about Heather? Yeah, stay the same.
Okay,
votes, yeah.
thank you.
Okay.
All right.
And then for House Bill 76, since Ehe is second, and there's a cross-file with Senator Carter, right? So can we just discuss that? Yeah, we'll wait for her. Okay. All right. Let's go to House Bill 248.
So House Bill 248, this bill has 2 separate parts. So the first part is the bill prohibits a condo and HOA from prohibiting or unreasonably restricting a unit owner or a lot owner from contracting with a private entity to collect organic waste material from the unit or lot owner for composting at the actual composting facility. The second part of the bill deals only with HOAs, not condos. So under this part, the bill prohibits an HOA from prohibiting or unreasonably restricting a lot owner from composting organic waste material for the lot owner's personal use, provided that the lot owner follows certain requirements.
So this bill comes out of my district. I'm familiar with it. And this is the second bill on this list today, HOAs, who are unreasonably trying to restrict certain things that they consider unsightly or for whatever reason. A couple of decades ago, when people started putting solar panels on their roofs, a lot of HOAs said, this is unsightly, we don't like solar panels. And then the legislature came in and said, HOAs can't regulate solar panels unreasonably. And now we see that some people keep small composting bins. Not composting bins that have a lot of stuff where the person is self-composting, but composting bins that are small and are picked up each week, as like recycling is picked up each week. They're taken to a composting center where they are composted there. And so in my district, an HOA that was a little overzealous tried to stop its residents from having these small composting bins, which are sealed and picked up each week. And this bill is to deal with that. So I would move favorably on this bill.
I'm just asking Jeff what the second half, that was, I think you just described the first half, right? What's the second half to? Or is it, it's the same, it's just HOAs and condos. Okay, maybe you're right. That appears to be what it is.
Oh, so just to clarify, the part about collecting organic waste to have a private entity collect it, that applies to both condos and HOAs. But if you want to compost it at your own place, that only applies to HOAs, not condos.
Is that the first half or the second half? I'm sorry, that's the first.
So looking at the bill, so the part that only applies to the HOAs, look at page 3, lines 24 to 29. You can do it like in a barrel or something. It's, I think that it would come under prohibit or unreasonably restrict is where it would come under.
Bill, I compost, it's my house. This just applies to condos, right? We're just extending this to the condos, right, Jeffrey? Homeowners and condos, right. This is an environmentally friendly bill too. I hope we don't spend 3 hours on this. It's. Can we move favorably on this bill?
All right, there's a motion for a favorable. It's been seconded. Is everyone okay? All right, excellent. Yeah. So let's go to the other HOA bill, House Bill 1347.
Portable basketball apparatuses. These HOAs, we should just outlaw them. They're out of hand. They're out of control. Basketball hoops. These are the little ones you move around. Move favorable, jerks. Second. Terrible.
So this bill prohibits restrictions on use from imposing unreasonable limitations on the location and use of a portable basketball apparatus, which is a portable basketball hoop, as long as the property owner owns or has a right to the exclusive use of the area in which the placement and use of the apparatus is to occur. So the restrictions that are prohibited, those would be restrictions that could be placed in like a covenant or a contract or a deed. So unreasonable limitations would include limitations that significantly increase the cost of using the basketball hoop or decrease the ability to use the hoop as designed and intended.
We had this in my neighborhood, not with this, but with, what you call it, trampolines. Oh my gosh, they made these people in your backyard? Yeah, they made them get all the neighbors' signatures, and they had to take it in and out at different times. It's in their backyard. Why do you care? So yeah, these are these little hoops you just move around. Move favorable.
is House Bill 297. So House Bill 297, this is the Maryland Lynching Truth and Reconciliation Commission report and sunset extension. So this is a sunset extension bill. It extends from June 30th, 2020 to June 30th, 2024, the termination for the commission. The bill also extends until December 1st, 2023, the deadline by which the commission must submit its final report of its findings and recommendations to the governor and General Assembly.
And I just throw in a little plug that, the history coming out on this is absolutely fascinating. I mean, these were things that were hidden that you didn't know that, at the turn of the last century, events even in your own county or something. So it's really, this is a good initiative because it's sort of like this part of our history that's been hidden. It's a secret, that family secret kind of deal that's just hushed up in the community. And it's something that needs to be reconciled with. I mean, this is totally in favor of this.
All right, excellent. It passes unanimously. All right, I'm sorry, House Bill 861?
Yeah, we passed that, but we passed it with amendment, and we need to strike the amendment, I think.
Okay.
So House Bill 861, we had, in the previous voting session, we voted this favorable with amendment. I incorrectly stated it needed a technical correction. It does not need that technical correction. So it would just be a straight favorable is what it needs.
Sorry.
Yeah. Are you talking about 861? Okay, cool. Great, thank you.
Yeah, let's just do the same vote as last time. It's 861, it's a reusable tenant screening application. Just same vote as last time? Okay. We get to, sorry, go ahead. House Bill 1061.
I think
So-
you're the only one not in your Southern Maryland coalition on whatever's going on with your commissioners.
So House Bill 1061 is the cross-file to Senate Bill 832, which was Southern Maryland Multifamily Dwelling Registration Fees and Fines. So if JPR wants to pass this, I recommend it, or one option is to do favorable with amendments. So the House bill, what they did to it is, so let me back up a second. So this bill requires or authorizes Charles County to require a property owner of a multifamily dwelling to register the dwelling with the county in order to offer units up for lease. It also authorizes Charles County to charge a fee on a property owner for registering the dwelling with the county. And lastly, Charles County may impose a fine on a property owner that leases a unit in the multifamily dwelling that is not registered with the county. What the House did is they further expanded this to cover dwelling units. So the bill defines dwelling units as a building or part of a building that provides living or sleeping facilities for one or more persons. So the scope of the bill would include multifamily dwelling units and dwelling units. If JPR wants to adopt this amendment to conform with the House is considering a technical correction to move the definition of dwelling unit down in the subsection that specifically deals with Charles County to avoid conflicting with another provision in the bill. That would just be a technical amendment, though.
Do you want to speak on this at all?
What's the easiest way to conform to 1061? That's it. I mean, the House, we voted the bill out clean. The House put an amendment on it. The Southern Maryland the Charles County delegation, 5 of the 6 members voted for the House version of it. Conform it to the House. Whatever the magic way to do that is.
Yeah, do you have okay, so we could let's amend the bill, adopt the technical amendment. Okay, so is it, everyone's okay adopting the technical amendment? Okay.
Okay.
Now, does it have a, you said it is 5-6. Or 5 members voted for it, 1 member did not. Okay. So does that mean is there a delegation letter then, or?
Yeah, there is
so
a
you still have it?
delegation.
Okay, good.
So we have everything here.
All right, Senator Castley.
I'm looking at the House amendment on the reprint. So originally it applies to multifamily dwelling units. Now it requires the dwelling units. Is that right? So dwelling units would mean a single-family home. So every single-family home in the county has to register?
If an individual wants to offer up a dwelling unit for rent, then yes. So a dwelling unit's defined as a building or part of a building that provides living or sleeping facilities for 1 or more individuals. And dwelling unit includes 1 or 2 family dwellings.
So every time somebody in Charles County wants to rent out their home, then the county can charge them a fee just for renting out their home. Jesus Christ.
Yes, they want that.
I'm shocked at how much stuff I got on this bill, which is, I'm happy to defer to the local courtesy. I just want to make sure that Charles County is doing, I got a lot of stuff saying this applies, and I believe it does under what council says, to renting a room out to in your house. So you can be dwelling in your own home, and you've got a college kid renting out a bedroom while they go to school, and now you're a landlord under the law of Charles County. I'll vote with you, but I got a lot of stuff from the Realtors Association and the folks from Charles County saying, so I'll defer to you. I just want to make clear what we're doing and make sure that that's what Charles County wants.
Local delegation is in supportive of this amendment. I've had extensive conversations with the Realtors as well, Southern Maryland Realtors. And 6 members of that delegation and 5 of the 6 members of that delegation. So that's what I'm doing.
Amendment, do you, further discussion, or you guys want it? Well, is everyone okay with that? All right, so go ahead, yeah. Senator Castle.
This is really troublesome to vote for, because what we're voting for is anytime, the whole idea of controlling multifamily dwelling units, and because there's lots of issues with landlords and stuff, but everybody who rents out their home has to pay a separate fee in Charles County just to rent out your home. And then like the vice chair says, everybody in a home that just wants to rent a room has to pay out a fee. This is the most, you guys are, Baltimore City doesn't require this. You have to register all your rental units to the whatever, you guys want it. That's Toyota, you asked for it, you'll get it. Go, that's fine. I just can't believe.
So, I just wanted to say I agree with the vice chairman. Out of all the bills that we are moving forward and we're looking at every day, my inbox, and of course I don't live but a mile from Charles County, but my inbox is completely full of people concerned about this issue. And there is, I know we say that this is a local bill, but there are issues sometimes when we do a local bill that then would have statewide implications because other people look at it. So I think that this is a significant issue that I don't know that we should just allow to say, well, it's local, so we just allow it to go.
While I appreciate what everybody is saying, if I don't like your local courtesy bill, look, I'm asking for the local courtesy. My delegation wants the bill. I don't live in Charles County. I live in Prince George's County. We have our rules there. But my duty is to present this on behalf of the Charles County delegation. So you can vote whatever way you feel like you need to vote, but I'd appreciate local courtesy because I would give that to you. So
That just a delegation. Oh, we have one from the county too?
Senate delegation letter, but not a county council letter or anything. That's all we need.
I'm not going to stand, I mean, Jesus Christ.
Vice Chair Waldstraker,
Yes.
Senator Lee,
This is what Charles County wants? Both Senate and the House, right? The Senate, House delegation? Okay, yeah, whatever you want, yes.
Senator Castley.
Pass.
I'm sorry,
Pass.
pass. Senator Huddleman,
Yes.
Senator West,
Pass.
Senator Sidnor,
For Charles County, yes.
Senator Jackson,
Yes, and I'll say this, I guess if we look at any piece of legislation, I guess we're supposed to be deliberative about it, and I guess we could look at someone renting a room in a basement, but I trust my colleagues who are from Charles County, as well as their county commissioners, who say they have problems with folks renting properties in their county that are uninhabitable. That's what they have put forth, that's why they voted for it, and that's why we're here. Yes.
Senator Bailey,
No.
Senator Carter,
Yes.
Senator Huff,
Yes, and explain my vote, unless it's like a tax increase, which I won't vote for those, or a speed camera. I generally give local courtesy, so yes.
Senator Castley,
Yeah, I mean, I'll vote yes because I respect local courtesy for it's just the residents of that county as opposed to bills that affect your county but affect everybody who goes through your county. So obviously it's for residents, so you'd have to be living there. So it's just really a bad bill, but I'll vote yes.
Senator West,
Yes.
Chairman Smith,
Yes.
bill moves forward.
House Bill 562 authorizes Montgomery County to decrease the maximum speed limit to no less than 15 miles per hour after performing an engineering and traffic investigation. So you have an amendment in your packet, which is number 756210/1. This would expand the bill to also apply to municipalities in Montgomery County. And I believe the vice chair also has an additional amendment.
Sure. So a couple of people expressed concern yesterday or 2 days ago about this bill because 15 miles per hour is pretty slow, and there was a concern that either the county or municipalities would take advantage of that to raise revenue. And so I was struck today, I think, on a Prince George's County local bill that fixed this very gracefully by saying anytime you lower the speed limit below the 25 miles per hour statewide standard for residential neighborhoods, you can then no longer put up a speed monitoring system to accompany that decrease in speed. So I asked council if he could draft an amendment that mirrored the Prince George's County amendment, and I would ask that we move favorably on that and the chairman's amendment.
So just to be particular about the amendment, so if you turn to the reprint on page 2 of 3, after the new language on line 19, there would be a new Roman numeral 3, which states, a local authority may not implement a new speed monitoring system to enforce speed limits on any portion of a highway for which the speed limit has been decreased under this paragraph.
Senator West. Got it. Senator West.
I'm waiting for the red light to go on. There we go. Why are we getting involved in prescribing speed limits in the first place? Shouldn't this be something that the Department of Transportation does?
We actually do it all the time. One of my favorite bills that we did was actually in your predecessor was for some reason adamantly opposed to it. I don't know why. When we increased the speed limit to 70 miles an hour, and we did it by legislation.
On interstate highways?
It was statewide, but it tends to be, quite frankly, out in western Maryland where you get most of them.
Well, beyond that, the language of the bill, Montgomery County may decrease the maximum speed limit to not less than 15 miles an hour on a highway. What does that mean? Decrease the maximum speed limit to not less than, so you can decrease the maximum speed limit to 20 miles an hour on a highway? Why would they want to do that? Does somebody from Montgomery County know?
You're asking why would you want to put it so slow?
Because some of these, especially in the municipalities, like we can't. You need the state to help to give you the authority to do this, but it's just a safety thing. I mean,
This is on a highway.
Do you want to give the definition of a highway? Because what I'm thinking about it's technically a highway, but it's a 2-lane road through a town, through a small municipality, like Carroll Avenue. Go ahead.
Just in the transportation article, highway is actually a defined term that includes most roadways, actually.
So Montgomery County could decrease the speed limit on the Washington Beltway to 20 miles an hour.
No, they could not.
Isn't that defines a highway?
Sorry, I didn't catch that
So
question.
the way we talked about this hypothetical is that if you gave Montgomery County this ability that they could lower the speed limit on their section of 495, for instance.
Not on 495, that would be under the state.
So that's not a highway?
It's not controlled by Montgomery County.
Oh. Montgomery County has no control over speed limits on the Beltway.
Correct.
Oh, interesting.
So, okay, I understand what a highway is now, but, under current law, without this, Montgomery County makes a 2-lane road, they pay for it, it's their road. Without this, I mean, it's their road, they're setting the speed limit. Without this, what's the lowest they could go?
The bill, this part is not in the bill, but there are some generally applicable speed limits that are set by state law. And then starting at the bottom of page 1 of the bill, in 21803A, this is the general authority for local jurisdictions to change speed limits. So you see that they can, on the basis of an engineering and traffic investigation, a local jurisdiction could, and they can do these 4 things. So they can decrease the limit at an intersection, increase it in an urban district to no more than 50 miles an hour, decrease the limit in an urban district, or decrease the limit outside an urban district to no less than 25. So this is just kind of giving them an additional authority on top of these 4 things.
So we passed this, Montgomery County says, this is a Montgomery County street, we think it's going through a neighborhood, we think we want a speed limit that's 20 miles an hour and not 25.
Correct. They would need to perform the engineering and traffic investigation first.
All right. Thank you.
You have the second then is to allow the municipalities within the county to do the same.
So the amendment that you have in your packet does that, and then the vice chair's amendment would be on top of that amendment.
Everyone okay moving the bill as amended? Excellent. Thank you. All right, so just to be clear, 967 still needs to be voted on by the delegation?
Yeah, we're waiting on the order for that. They're voting tomorrow.
So Senator Carter We've got your cross file here with Delegate Love. Is that right? Do you want to? Can we go to that bill? Start discussing that. So I guess we'll start with House Bill 76. We'll move yours to let Councilman then Heather and then just describe the bill and then
So House Bill 76 is the cross file to Senate Bill 334. The House did amend House Bill 76. So first I'll go over what the bill did as introduced and what the amendments did. So generally, a party to a civil action must be authorized to participate in the action, whether by statute or by having common law standing. And generally, federal law is broader than state law in determination of standing. So under this bill, a person who meets the threshold standing requirements under the Federal Clean Water Act has an unconditional right and the authority to intervene in a civil action brought by the state in state court to require compliance with certain water pollution control laws related regulations or any related discharge permit, effluent limitations, or order issued by the Maryland Department of Environment. So there are two different amendments by the House. So the first amendment was that the term "a civil action brought by the state" was replaced with the term "a civil action initiated by the state." This amendment's purpose was trying to clarify that the bill does not apply to administrative proceedings that are appealed to the courts. That was requested by the opposition or favorable with amendments testimony.
unfavorable. Never mind. Keep going.
The Second Amendment specifies that a person exercising the right to intervene under the bill must act in accordance with applicable practices, procedures, and laws in the state. So those are the two separate amendments that the House put on the bill.
Just trying to understand what the bill does here. So in the First Amendment,
Thanks. Maybe I'll answer your question. I hope so. So it's pretty simple. This two-page bill basically closes a loophole in law, I would describe. I know people say that all the time, but it does. So the Federal Clean Water Act gives citizens an unconditional right to intervene in these kinds of actions. And in order to have Marylanders exercise that right and be able to intervene in these suits, whether they be brought in federal court or state court, Maryland needs to pass this law to give our citizens that right. Some of the discussions earlier on, and it's been a long time, I think this bill was heard in January or very early in February, but I remember there were discussions at that time about whether this affects standing. It clearly doesn't, even in the amendment that committee counsel read. This is not about that. A person would not have a right unless they meet already predetermined standing requirements. So it's a pretty simple bill. It would just give our constituencies a greater ability to participate in these kinds of actions, water pollution actions.
but that is standing. You said it doesn't change standing, but it does change standing, doesn't it? I mean, if they currently don't have if they had standing already, this bill wouldn't be here. So clearly the problem is that you're saying you want to give them standing, so they don't have standing now. So it's all about giving a whole other class of people standing to intervene in these lawsuits.
Standing is a different section of the law. So if a person didn't have standing already, they wouldn't be able to intervene. So this isn't changing whether they have standing or not. I understand that it's confusing because intervention is technically not the same thing as standing.
Yeah, but you can't intervene if you don't have standing. I mean, how can you intervene?
Correct. So if they don't have standing, they can't intervene.
Right, so this is saying they can, so you're giving them standing to do that. mean, if they already had standing to do that, why wouldn't?
Heather, could you reread that amendment? Because I felt that it kind of clarified the issue between standing and intervention.
So the amendment by the House was on page 2, lines 11 through 13, stating, "A person shall exercise the right to intervene under subsection A of this section in accordance with applicable practices, procedures, and laws in the state."
So, yeah, I mean, I think I'm a supporter of the bill. I'm going to vote for the bill. I'm going to vote for the bill because it expands standing. I mean, it doesn't expand standing to sue, which I think is the clarification. It expands standing to intervene, and that's the distinction that's being made here. So if you could have intervened had this been federal, now you can intervene in this state matter. And I just want to be honest about what we're doing.
Yeah, I think there's actually an excellent like flow chart in the testimony, because I didn't understand. I was like, break this down. So the polluter allegedly pollutes, goes down to an impacted citizen, group, or person in city or county, brings evidence to the attention of the violation to the MDE. So the citizen then gives 60-day notice of an intent to sue. There you go, there's your standing there. You got MDE takes no action or MDE takes legal action against the polluter. You either go to federal court or state court. You have federal court, the citizen must demonstrate standing to intervene. And if you go to state court, right now you cannot intervene. And that's what this bill fixes? Is that right?
I think it's a higher bar to intervene on the state side versus federal side. That's what the advocates, I think.
Got it. Understood. Okay, so that room. Okay. If you look in your testimony, there's actually a pretty good explanation. But anyway, good. I'll defer to counsel, but we're just talking about the process and why the bill is necessary. I don't.
So,
I think anyone.
But it's necessary. Again, because there was a case that went to the Court of Appeals, and the Court of Appeals, it was some years ago, the Court of Appeals decision made it clear, and I can pull that up if necessary.
Okay, so as I understand this now, then these folks already have standing to bring their own lawsuits, and what they currently can't do is intervene in a suit brought by the state or brought by somebody or a political subdivision. They bring a suit that doesn't give everybody else the right to intervene in that lawsuit. They can, on their own, based upon the federal law, file their own lawsuit if they want. And what this would do is say, well, you can all jump on as parties in this state-filed lawsuit, right? Isn't that what we're saying? I can't really, I don't have my glasses on. That's a yeah. I'm sorry.
a new standing, it's saying that if the state has filed and you have standing
To
separately,
intervene.
but you want to be in on that case, you already have standing. It's just saying you can intervene.
Right. So, and now, as I understand, the pushback that we're seeing on behalf of the various government entities is that we have this lawsuit, the state's pursuing it, and then all of a sudden we end up with all these other parties coming in who are all just going to intervene. So instead of having, Montgomery County versus ABC Corporation, we have Montgomery County and these 15 other people who are also intervening in this lawsuit.
The opposition that was raised by the counties or municipals was that it could make the proceeding last longer because you'd have more parties involved, was the opposition.
They make a good point because, the municipality goes through all the expenses of drafting, researching it, drafting the complaint, getting everything going, and now the intervener just intervenes, and now they're a party in every deposition. They ask all the questions. They show up at trial, and so now you have this really expanded lawsuit that gets rather convoluted as, the municipal attorney's asking questions, and now he's got 10 more 10 more people there to ask questions in the depositions, and kind of freeloading off of the municipality's legal work and expenses just to, step into the lawsuit. And then you get into the courtroom and they just sort of walk in knowing all the legal work's done, and I understand the opposition. Thank you.
And my understanding is, and perhaps the sponsor can elaborate, that the amendments have done away with the opposition. I know there was a lot of opposition testimony, but my understanding is that the amendments address that. That's just what I've been told.
At least a couple of the opposition, one from Baltimore City and I think from Mako, were taken, Maryland Association of Counties were taken away. I can't speak to each individual opposition, but I do think that they alleviated the amendments that Heather read.
Can I just, specifically the opposition, I see one, I think MML and Mako were both opposed. Are they still opposed?
I'm clarifying, but I don't believe so. I was informed that the amendments satisfied their opposition. Do you have different information?
I have not received updated testimony. I do know that some of the opposition was favorable or had recommended amendments, which these amendments do. But if just looking at MML, they did not have suggested amendments in their testimony, so I don't know if they're still opposed or not.
What about Mako? What did they say?
I don't have an updated testimony from Mako either.
I'll find out.
Could you? That would be.
Let me find out.
If MML and Mako are fine with it, they're the experts in this area. It would be really helpful to know that. I realize there's other people, but I think they're the real experts in this. If they're fine with it, then.
Saying no, they're not opposed anymore with the amendments, but I'm getting the emails right now from them.
Okay. I mean, if you got I trust a text message. If they're saying they're not opposed, I take a text.
Okay.
Okay. Yeah, the sponsor bill said Mako's no longer opposing it.
I'm sorry. You say that, what do you say?
Mako is not opposing it. I just talked to the sponsor.
Then they're what? I couldn't hear you, Susan.
Mako? Mako is not opposing the bill.
Thank you.
Thanks. Sorry.
It's all right. I heard you.
According to
that they're no longer opposed. I'm getting emails right now. Actually, I just got them right now. Okay. Yep. So first we've got to Senator Carter to conform.
Why don't you got to pass the House bill first.
All right. So we have
and
to.
then amend it. Right.
So you can pass the House bill and then amend the Senate bill to conform to the House bill.
Okay. So is everyone okay with passing the House bill? Okay, great.
Favorable.
Favorable.
Yep.
All right. Now, Senator Carter, can we amend your Senate bill to conform with the House bill? Okay. Is everyone okay with that? Excellent.
Oh, there's House Bill 260, which is House Bill 260. That was the jury one. Yeah. Yeah. Sorry. That's an easy one. 260.
She's got a reading comprehension problem.
All right, we'll pick up with House Bill 260.
So House Bill 260, this is the cross file to Senate Bill 625, which was Senator Carter's jury selection or jury disqualification bill. So the House passed the House bill clean. So if JPR wishes, I would recommend amending the House bill to conform to the Senate bill. What that would do is an individual is not qualified for jury service if the individual has been convicted in a federal or state court of record of a crime punishable by imprisonment exceeding 1 year and is currently serving the sentence imposed for the conviction, including a term of probation.
I like what we did better.
That sounded eerily similar. What was the difference?
That was ours.
That's
Okay.
Yeah.
Yes.
Okay, and what was there? And did they?
The House passed it clean.
Right, I know. I was wondering. So they didn't send
charges
anything
and-
over like what they wanted.
Can you read that one more time, what we did?
Sure. So this is what JPR did. So an individual is not qualified for jury service if the individual has been convicted in a federal or state court of record of a crime punishable by imprisonment exceeding 1 year and is currently serving the sentence imposed for the conviction, including a term of probation.
Okay, now
So-
you just confused me again.
So the other part is JPR put subsection 5 back in, which is the person is disqualified if the person has a charge pending in federal or state court of record for a crime punishable by imprisonment exceeding 1 year.
Yeah, but the way that Heather just read it, it sounded like we continue to disqualify people that were convicted of felonies. That's not my recollection.
So they've been convicted and they're currently serving a sentence imposed for the conviction,
So once you're
including
out
a
of the-
term of probation. So they have to be convicted and they're serving. So if they're no longer serving, then they can. Yeah.
Okay. That's my recollection. Is just the way she said it.
Yeah,
It sounded different.
Exceeding 1 year.
Proceed, conform to the Senate.
Yeah,
Be favorable with amendments.
Favorable with amendments on the House. Conform to the Senate. Let's just go into conference.
Okay, but not yet.
Not yet, I know.
So, is everybody good?
Everyone's good with that? All right. Senator Jackson, what was you had a bill on here?
Me about House Bill 483.
House Bill 483 limits the hours during which a person in possession of a vehicle that has been towed or removed from a parking lot is required to provide an opportunity for the vehicle owner or their agent to retake possession of the vehicle. Under the bill, the vehicle must be available for reclamation from, at a minimum, 6 a.m. to midnight rather than 24 hours a day. The bill also makes conforming changes to signage requirements.
If there's something late at night, you can't get your car back now.
I think we've seen this bill before, haven't we?
Yeah, I think we killed this bill. Doug Peters had this bill one year and we killed it.
I think we did do that. Sorry, go ahead.
Yes.
Go ahead, Josh.
I believe the committee voted on it, but they heard a similar bill last year.
I remember defeating Doug Peters' bills because I try to avoid that since he's chair of the capital budget. But no, so we've always had a lot of restrictions on tow companies because they take your car. You know, we're gonna kill it. Look, they charge you absorbent fees. And now they're like, I remember this bill because Doug came in and is like, oh, the tow companies were like, oh, they're like aggressive. And people are coming in real pissed off and want their cars. Like, yeah, people were probably really pissed off because their car got towed. So no way, if I'm like downtown someplace, my car gets towed, that's like dangerous to leave me out in the middle of nowhere and I can't get my car. I got to go to a hotel all night because the tow truck company got a bill down here in Annapolis to say we don't have to be open at night. That's terrible. Move unfavorable on this.
Look,
Awful.
Look, let me say this. So, Mr. Chair, thank you. I got a text from a colleague to ask me, it's on the voting list to make sure the committee voted. But I think Senator Peters, I don't know what you heard last year, but this tow truck driver that instigated this, that initiated Delegate Turner putting this bill forward, lives in Bowie, lives in Senator Peters' district. He actually got killed. And that's probably where that came from. Because I think during the testimony, I think that's who we heard from. So that's the premise of the bill. I was texted by, a colleague, the bill before the, and it's not a local bill.
I remember, yeah, that's obviously tragic. I
it's not
remember
a
there,
local bill,
the
so.
testimony last time was just obviously a cost saving.
Thank you.
But, this is a second on that. You upheld your end of the bargain. You put it up and it got a vote. So we didn't see, you didn't, all right, so motion was for unfavorable. It's been seconded. We can roll call it if you want. Let's roll call it because I know some people are going to have to fight like a tiger.
Is anybody in favor of leaving people stranded?
I think we've got some people that may fight like a tiger, but let's roll it.
Vice Chair Wallenstraker.
Yes on the unfavorable.
Senator Lee.
Yes.
Senator Castley.
Yes.
Senator Hedelman.
Pass.
Senator West.
Yes on the unfavorable.
Senator Sidnor.
Yes.
Senator Jackson.
Yes.
It says tow truck companies can tow your car and just leave you, and like they don't have to be open all day now.
Is that really?
I didn't hear
Still.
Senator Jackson.
Oh, yes.
Still do bill?
To no.
Change it. Okay.
That's the only reason why we rolled this thing. Make sure you fight like a tiger. I'm sorry.
Senator Bailey.
Yes.
Senator Carter.
Shit, I'm sorry. That's just funny.
At the risk of making the committee angry and frustrated with me,
No. Vote away, whatever you want.
No, I'm not-
The vote's already done. You can vote whatever you want.
I got you. I wasn't sure why I wasn't paying attention to the bill. I don't remember it. Why don't we like it? Why does everybody hate
They
it?
can shut down, if they tow your car, they can shut down the lot from midnight, for a minimum of 6 a.m. to midnight.
Oh,
It used to be open 24 hours a day. You could get your car back.
Now you can get your car anytime. Now they want to say you can't
Correct,
get it unless it's
correct.
morning. Okay.
You drive out to Frederick.
Okay, yeah. Yes on the unfavorable.
Senator Huff.
Yes.
Are you sure?
On the unfavorable.
Chairman Smith.
Yes on the unfavorable. I like how you always say,
Oh wait, hold on. Sorry, Senator Hedelman.
Yes. Yes.
Nice move, Mr. Chair. Now that we all already got our.
No, he didn't bring that in.
he was like,
Did he? Doug didn't have the crossbow.
no, he didn't have a crossbow, yeah. He's like, so you drive up to Frederick at midnight. Oh my God. All right. That was bad.
Go down the hall or something.
House Bill 23 modifies the Public Information Act to require an officer, employee, agent, or contractor of the state or a political subdivision to deny inspection of specified records and deny inspection using facial recognition searches by any federal agency seeking access for the purpose of enforcing federal immigration law unless provided with a valid warrant. In addition, a person who receives specified personal information under the PIA may not disclose the information to a federal agent or federal agency for the purpose of federal immigration enforcement unless presented with a valid warrant. The Motor Vehicle Administration, Department of State Police, and Department of Public Safety and Correctional Services must submit a specified annual report to the General Assembly on requests from federal agencies for immigration enforcement purposes. Finally, the bill restricts access to databases operated by state and local law enforcement agencies. So the committee also has the Senate cross-file, which is Senate Bill 234. And you should have an amendment in your, on your desk for that, which is number 978477/1. So this amendment conforms the Senate bill to the House bill and makes a couple of additional changes to address concerns that were raised in the revised fiscal note about the database provisions and the possibility that those provisions might affect certain routine uses of state databases. So just to quickly flag what the differences would be between the Senate bill and the House bill with the amendments, if you go to page 7 of 8 of the reprint, in the definition of database, the Senate bill would additionally exclude the sex offender registry from the definition of database because that is a public database, and this would simply ensure that access to that is not affected by the bill.
Let's just work off the House bill, and then let's talk about the amendment that addresses the opposition, in particular from public safety.
Okay, yeah, the amendments to the House bill were to address some opposition from MVA and public safety. So they did a couple of things. Those amendments added the provisions which prohibit an individual who receives personal information from sharing it with federal immigration authorities. They also limited some of the reporting requirements to just those three agencies, the state police, the MVA, and public safety and correctional services. And they also modified some of the database provisions to make sure that those provisions were doing what the advocates intended and weren't stretching a little bit too broadly. So with those amendments, the public safety and correctional services and the MVA withdrew their opposition to the bill.
So let's just go opposition, let's go MVA opposition, and then how the amendments address that opposition. Let's just take it one by one. Their opposition, and then how exactly do the amendments address that opposition?
They're easy.
So the MVA's opposition, I think, was focused on the Port of Baltimore and the possibility that certain uses by the port authorities that are necessary to carry out their duties might be affected by the database provisions of the bill. And I believe I was not involved in crafting the House amendments, but the pieces of the House amendments that that clarified the definition of law enforcement agency and that allowed access to a database when a statement is provided that the individual is acting on behalf of a law enforcement agency. I believe that was what addressed the MVA's concerns.
So I'm looking at, it's actually not MVA, it's MDOT, right?
Correct.
Okay, so MDOT's opposition, so they have a 2-page letter, and the first paragraph says, we don't control this. Okay, so then you get the last paragraph, and they talk about Port of Baltimore operations and maintaining the security of the port, because as we all know, ports are high risk for smuggling of people and contraband, and so they conduct apparently checks with Coast Guard so they can maintain security of Dundalk, Seagrit, all these major terminals, international terminals. How have we addressed that concern?
I apologize, Senator, that I was not involved in crafting the House amendments, and I haven't spoken to MDOT personally. I
Yeah.
As I've been told by counsel over there that it addressed their
I mean,
concern.
I would just suggest it's a major, I mean, these big international ports, there's like 6 of them sitting in the heart of the state, and them being secure so we don't promote human trafficking, smuggling, international smuggling operations is a pretty major concern. I'd really like to know if that concern has been met. What about, there's a second concern, their ability to work with Customs and Border Patrol, but they do share information. They don't do customs immigration, but they do share information for security purposes. And there's no way they could guarantee what their federal partners are doing with the information, but if they can't cooperate with them, then that impacts directly the security of these ports. I think, and then they also raise the same concerns with regard to the airport security, that it's a secure environment. We've got BWI, Thurgood Marshall, another major international airport, to properly vet individuals hired to work at the airport, because again, airports like shipping ports are prone to be hubs for human trafficking and smuggling operations. They could even jeopardize our national security. So it'd be really good to know if these concerns have been addressed. I mean, we've got, what we're basically saying is, let's not cooperate with the Biden administration. That's what this bill says. We got 4 years of the Biden administration at least, and we're saying let's not cooperate with them. It's not a resounding notice of confidence in the Biden administration for us to do this. I'm just curious why we feel the need to push this forward unless we can be certain that we're not foolishly and needlessly jeopardizing the security of these major ports and airports. And that's just MDOT's. We haven't even addressed yet the Department of Public Safety and their operations as well. They have a 3-page letter that's got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 bullets of concerns that they raise. It'd be good to know if we've addressed those bullets. Again, we're saying that, well, we can't trust the Biden administration, so we're going to jeopardize our own state safety and operations.
I mean, again, I wish I could kind of tell you exactly what the thought process was, but I haven't spoken to MDOT personally on it.
Let's through this.
All right. Let's do. We've got the. Let's just. Can we just take one action? We'll just conform the. Do we have to? Hold on. To the amendments that I have here, just make the House and the Senate in the same posture. We're not taking action on it. They basically just make the Senate in the same posture as the House. Is that right?
A couple of additional things in there that I think speak to the concern in the revised fiscal note.
Go talk just. So I think that there's something that just is actually ongoing, just went down, dealing with Baltimore. And when we talk about the port, some of the guys that I used to work with just sent me these pictures of all these kilos of cocaine that they just got off of a ship going in there, and it was done by the Customs and Border Protection along with the state and law enforcement agencies. The ones that were doing it, the Keith Fleming, the acting director of the Field Operations Bar of CBP's Baltimore Field Office, Homeland Security investigators, special agents were working diligently to trace and identify this criminal drug activity taking place. They had Special Agent in Charge James Mancuso for HSI's Baltimore Field Office, the Coast Guard, the DEA, and holy smokes, even the Maryland Natural Resource Police. That's why I'm getting this. But anyway, it was a boat, very large seizure, talking millions of dollars worth of cocaine that was just taken out of there. I sent it to you, Mr. Chairman, if you'd like to take a look at it. But it's ongoing, and I do have some questions and things before we start conforming this bill that I'd like to look at with this information.
Okay, so we'll hold off on the confirmations until we walk through the amendments. But Senator Heddleman, go ahead.
I just wanted to say that that I do have some information about that there would. Let me just see here. That I think this was discussed that there were some state agencies that were concerned that they would have to certify or obtain certifications, and I have here something that says there's no certification requirement in the bill. In fact, they anticipated those concerns and wrote it to clearly avoid them, and I can send that to the committee if they're interested in that, based on some things that had happened in New York and excluding any kind of certification language. So I can share that if that would be helpful to clarify. Yep. Oh.
I do not think that I do.
This is written by somebody for the Center on Privacy and Technology at Georgetown Law.
Position points and then amendments, how they address, and we can incorporate the kind of the certification language. I don't even know, we have to slow walk the process. What does certification mean? You know, why do you need it? And then how do you prove that it's only for non-immigration purposes? Like, have that explanation, just kind of, we'll slow walk through that. And then we can do the same thing with the MVA as well. All right. All right, Senator West. Yes. You had, was it a 250?
250 is the bill that allows certain trucks to get checked out less frequently. This is for the Maryland Truckers Association. We had the testimony. If I can find it. Sorry, here it is right here. It increases the mileage between preventive maintenance inspections for tractor trailers from 25,000 miles to 35,000 miles. And even if this passes, Maryland will still have the strictest inspection rules in the country. But companies that who invest in the newer trucks will get the modest increase of time between checkups.
Only perspective?
Yes. Yeah, it's only perspective.
You got an old truck, you still got to go by the old system?
Yes. Let me go back and find the bill. My recollection from the testimony is that the only trucks that would be covered by this are new trucks.
So it would actually apply to, all Class F tractor vehicles and electric Class E truck and dump truck vehicles, as long as they were in their first 5 years of operation. So once you get out of 5 years, then you're back under the old regime, basically.
House Bill 250.
So the current law is you need to do it at the earlier of 25,000 miles or 1 year. So under the bill for Class F tractor vehicles, it would be 35,000 miles or a year. And for the electric trucks, it would be 50,000 or a year.
And while I'm up, can we turn to the, there's Bill 7, House Bill 781 is the cross-file of my miscellaneous corporation bill, and I'm about to stand up on the floor in the next session and concur to this bill to make our bill from the Senate the same as this bill. So we should pass this bill. It's 781.
It's been seconded. It's not going to be on the floor tonight, though. Just an FYI. Okay. All right, I have.
You have two concurrences, don't forget.
I know.
Okay.
Then we do. Let's do these two, and then we'll do the concurrence. House Bill 322.
House Bill 322, Real Property Restrictions on Use, Low Impact Landscaping. So this bill defines low impact landscaping as landscaping techniques that conserve water, lower maintenance cost, provide pollution prevention, and create a habitat for wildlife. This bill prohibits unreasonable limitations on low impact landscaping if the owner owns or has the right to exclusive use of the property and maintains the low impact landscaping. Yeah.
Explanation of that bill. Just to be honest, Heather. No, I don't remember that hearing unless somebody else can explain what. I don't know what low impact. I don't know what they're talking about for this these plants or whatever and what they're trying to do here.
Yeah, so low impact landscaping, the bill actually says what it could include. So it could be a pollinator garden and other features to attract pollinating species, biohabitat gardens that are designed to attract wildlife, rain gardens. So if you want to put in, say, a rain garden or a pollinating garden, like this bill would allow you to do that, so long as so as long as the owner owns or has an exclusive right to the property. So if it's in your front yard, and then you would also have to be required to maintain and regularly tend your low impact landscaping.
I remember the hearing now. Does this apply to all residential, or is it just like a condo or a HOA? How, I forgot, why, was there some kind of prohibition or something by a neighborhood or something? Why they brought this bill?
So a neighborhood, it doesn't have to be an HOA, but you could have a neighborhood that would prohibit, say, a rain garden from being installed. They could require all lawns to not have any features on it, just a plain grass. But this would say
in
you
certain
can
localities, are there laws that ban this type of garden? Or there what? In covenants.
So it nullifies a deed or covenant.
Oh, okay, okay.
They don't reference state law or county law.
But it's contractual then.
It's just contractual.
Okay. Who would ban that? Gosh, what a horrible bunch of neighbors. I mean,
just to be clear, it does apply to condos also. It's not exclusive to condos. It's everything, right?
I will say this is the first time I've seen exerscaping in a bill. What the hell? I had to look that up. The practice of landscaping with minimal use of water. Homes, businesses, and deserts.
You have like brown grass.
Yeah, like climates like Las Vegas use rocks and native vegetation. And cacti.
Somebody's gonna have like cactus and sand lawns, and we allowed it. They're gonna be like, "Why are these cactus and sand lawns in my neighborhood?" We're like, ask the Maryland Senate.
Basketball hoop and a big ass composting area.
Oh Lord. Every neighbor's gonna look like a trailer park when we're done with this thing.
I just want to know if you could grow your cacti in the bed of that pickup truck sitting out there in your yard. You know, actually, when I mean, and granted, I come from a rural area, and obviously, we don't deal with many of these homeowner policies that people. You know, if I wanted to put in a garden, obviously, I'd put one in. If I wanted to, however I maintained it, would clearly be my right to do it. The thing that scared me a little bit about when I read this, it said you had to maintain it in a certain manner. Is that true?
The House amended the bill, if you're looking at page 3 of the bill, line 3, specified that you would have to maintain and regularly tend to the low impact landscaping.
So who are we going to send? What police department are we sending out there to and say that somebody didn't cut back their butterfly bushes?
You already have a restriction that you can't do any of this. We're saying you can do it, but your HOA, they could come back and say, well, just because you have a natural landscape doesn't mean you can have, you know, briars and weeds 3 feet high in it. You still got to maintain it just because it's a low impact. So what we're saying is, I mean, currently they can't have it at all. We're saying you can have it, but the HOA could restrict you and say, well, you got to maintain it. If you got that, we're not saying it's a wilderness thing. The HOA could still come back and say, well, just because it's low impact doesn't mean you don't have to weed it. Currently, they can tell you to do everything they want to. So we're not putting in an enforcement mechanism. We're allowing the HOA to say, okay, you got to let them have it, but you have to maintain it.
Everyone okay? Sorry, Bill, yeah.
Hey, her bill's 931.
You want to bring that up? Yeah. All right. Let's do this. Let's do 781 first, and then we'll do that one. Hold on. We did 781? Did we move on 781?
Yeah, you did.
Okay, got it. Yeah, we did. Sorry.
So, should I do it? Senate, or House Bill, yes, House Bill 744. This bill prohibits a circuit court clerk from collecting a fee for docketing the appearance of a petitioner or a respondent's counsel in a domestic violence protective order.
Oh, wait, sorry. Sorry, we don't. Oh, yeah. Yeah. But hold on, we've got an amendment real quick. Is it this one?
No, it's Erica's bill.
Oh, sorry. Okay.
There are no amendments for this bill.
Got it. Is there any discussion on it?
I used to represent SARC. I think I did like 300 of these cases, and they were like reduced fee or pro bono, and you know, to be hit with an account. Quite often, attorneys do these things for a pro bono or reduced fee. I think it makes sense. You don't get them hit with whacked with a court fee for their pro bono services.
So 781 passes unanimously. Sorry, 744. I keep saying 781 for some reason. I don't know why. 744.
Are we going to be much longer? What are you going to do?
So this bill requires the designee of a state superintendent of schools, upon receipt of a required notification regarding suspected child abuse within a child care facility, to ensure that the notice to parents, that notice to parents and guardians has been provided. Family child care providers and child care centers must provide notice to parents or guardians of all children who are under the care of the provider or center of a report or incident of suspected child abuse or neglect that is alleged to have occurred on the premise. The bill also establishes additional requirements for the notice and establishes related civil penalties.
9:30. Let me tell you a moment. So I talked to her. She's good. I mean, this is a simple bill. It just says if there's an issue or an occurrence in these child care centers, you got to notify the parent or guardians. That's it. That was pretty simple. I talked to her, and she's okay with, I told her I'd like to amend on my statute of limitations bill that we passed unanimously out here, dealing on the criminal side, just removing it, that if somebody interferes with a mandated reporter, to put that onto here, because I think the House looks like they're not moving some of my stuff. So she actually was very happy with putting that on there because it greatly improves her bill. So I just want to take that provision that we passed earlier unanimously, dealing with the criminal statute limitation, preventing and reporting, and put it onto this bill.
You don't know what that was?
Nope.
I'll find it.
I guess I was concerned by some of the things that the Child Care Association said. Yeah, I mean, I think they raised some good points. I feel like there's something else we need to do this bill. I'm not sure what it is yet, but you know, if somebody makes a call to Child Protective Services, we're saying, like, I don't remember what the bill says, but pretty immediately when you have to then, for example, if it happens in a kid's classroom, then you need to notify the parents. And I guess my question is, what are you notifying? Just that you made a report to CPS and that there are allegations that a child was abused in that classroom? And then I guess I'm just sort of concerned about I would want to know, being a parent, I would want to know. But then, of course, my next question is going to be who, what, where, why, and was my kid, exposed to that potential abuser? And the facility can't answer any of those questions, I think. And so I think it raises concerns about what good this does. And so I guess I just wonder, I understand the purpose of it, and I understand, like, I would want to know, but I'm not sure what I do with that information.
I don't know. I thought about it and I listened carefully, and then I read the bill again, and I was thinking, like, if my daughter enrolled in childcare and someone was alleged to have had that happen, I would want to know immediately. And so if they're saying these investigations can't happen in 24 hours, it needs to happen in 24 hours. Like, I know the investigation doesn't happen in 24 hours, but notification of an allegation like that, you better tell me in 24, or, you know what I mean? That's the way I was thinking. I mean, obviously my worldview has changed a little bit in the last 3 years, but for me, I was like, that was a non-starter, so.
I'm just going to say, I think.
With the notice, what is in the notice? Because what if later on the allegations are not proven to be true? You're worried about people's reputations or stigma and maligning, especially if they're not found to be true. Like, what do you put in the notice? Only that you don't identify. You don't identify anyone, do you? Or
so it's on page 3 of the bill.
three?
So
Of the third
lines
read, the-
10
Okay.
through 23.
So in listening to this yesterday, I think the educators had raised a question that the inference in the bill or the bill stated that everyone in the school needed to be, all the parents needed to be notified. And I think, I can't recall completely, but was there the challenge of the timeline that every parent of every student in the facility need to be notified? I think that was one of their concerns, I believe.
It's all the children under the care of the child care facility.
Right. Okay.
The notice required can also be electronic. So you're telling me it's going to take you a ton of time and resources to send an email to your listserv for people that are already enrolled? I mean, give me a break.
So we're, I know how this, for example, for Frederick County Public Schools, they do a pretty good job. We get emails from them from the elementary school and also for all my kids' schools. I get emails, I get text messages. They do a good job of alerting us. And there's been a couple times where something came up and they alerted us, hey, this incident happened. We're just making you aware. And just quite frankly, as a parent, that's all I want, is just to be aware. I don't want to read in the paper a month later, this happened, I didn't even know about it. So I think this is a good policy.
Yeah, I think the intent of this bill is really good. I would want to get notified if, my kid was in a facility and, so just, there's just a report that something happened. It doesn't identify anybody, like, or the particulars, only that there was a suspected incident, right? What goes into that? What does a notice look like?
So
Give me an example.
All the notice requirements are in page 3, lines 10 through 23. But so they may not provide. Yep.
Okay, it's in writing, person, electronic. So it's just a statement that there was some suspected incident, but it like none of the particulars, right, Heather? What does that mean? Like.
So it simply says a statement. It does not require that any personal identifying information be included in the statement, just a statement that a suspected incident of child abuse or neglect
right?
has occurred.
13 to 19, right?
Lines 13 through 15, C1.
Mm-hmm. Yeah, I see that.
And then also the contact information for the local child advocacy center and any other appropriate information relating to local resources for child mental health care.
Okay, that's it, that it happened and this, and the contact information, all that stuff.
Correct.
Right. Okay.
No, I'm good.
No, I'm good.
Thank you. I have a question about reporting requirements or notification requirements in public places. Like, if schools make a report to CPS, do they then have to have any obligation to notify their parents?
This is on the premises of this statute. I mean, this bill says requires, it only relates to have occurred on the premises.
I know.
Okay.
But I'm asking that parallel question about public schools. And do we know?
I don't know. There's conditions on mandatory reporting, but that's
Right.
making a report.
Right. That's right. So I'm just putting this out there. I don't know that we have any, I don't think we have anything similar in public schools. And my other question is,
Matter?
I'm just wondering if we're just entering new territory
Yeah,
here.
yeah.
And the other question is, do we notify are we comfortable notifying the entire school? Is that what we want to, I mean, the entire child care center? Is that what we want to do? Or give discretion to the center at all with, anybody who may have come in contact with the
It's
person
all the
about whom they're
children. So
reporting?
it's the guardians of all the children who are under the care of the child care provider.
Right, so it's the whole place.
You have to be attenuated to the child, though. So it's like if you work there as a custodian or you work there as a teacher, you're not under this. It's the children tied to their guardian or their parent.
No. That's not what I'm saying. I'm saying if there's somebody who is alleged to have been abused, right? So my question is, does the child care center have to notify the entire population? You know, if you have a child care center that has 200 kids or whatever, are you notifying all 200 or only the ones who may have come in contact with whomever you're reporting about? Right.
Closet.
I mean,
Schools, we do require that. I did one of the bills for public. We require that they get a background check. So even the contractors that go in, because in Montgomery County, actually, they had a problem with the contractors. Some of them were
Right.
like sex offenders and like molesting kids or grabbing them.
in child care centers, you have to have background checks too.
I don't know that we mandate that in law, though, do we?
I'm pretty sure we do. Yeah, I'm pretty sure we do.
So, Senator Huff, I don't know if you've gotten one of these or perhaps some other folks with kids in school, but I've gotten COVID notifications from my school, and it goes to the entire, so I got one today. It goes to the entire school regardless of where in the school it happened. It doesn't identify the person who got it, and it indicates that, like, if there's something specific to you about this notice, you will get notification from us separately. And so as I analogize that to the bill we have in front of us, the bill seems to follow that. And I'm comforted. I mean, when like Senator Hedelman said, when I get a letter like that, I'm curious who got it, and I'm curious how close my kid was.
Right.
But I'm also comforted knowing that they're telling me I'm not reading it in the newspaper. And I'm comforted that if I don't get any other notice specific to my child, that my child was not part of the danger that was indicated for the COVID notice. And to me, this bill just reflects how we handle COVID in a very different circumstance, but in a notice structure that is familiar to us and comforting.
So I understand that, but I want that second notice. Like, I want to know if my kid was potentially around that person, right? So you want to know if your kid was exposed. I would too. And I'm just concerned that this just is like opening this, firestorm without other information that's particularly helpful to the risk that my child faced, right? That's my concern. I don't, not with young kids, you're not.
Yeah, so let me say this. Having had my my deputies in schools and having had family members that are working in Catholic schools and other places, so the general notification goes out. Hey, this occurred on campus. And as the vice chair says, if any information specific to you is necessary, the investigation will lead from the investigation, internal investigation, then you'll be notified by the proper folks. That's typically how it happens. I think when I spoke earlier, I was just a little concerned when the young lady spoke of the notification of everyone. But I think the conversation as it went on, I think it got settled. I'm not sure because I think I had to drop off the hearing or something. But I am comfortable, and the chairman just left. Mr. Vice Chair, after this bill, there was a bill that was heard the other day. I'd like to get on the list. Thank you. 962.
No, I just, it says they also have to include in their contact information for the local child advocacy center and any other appropriate information relating to local resources. So I think we can leave it up to the professionals in this to do the appropriate thing, and as parents call in to say, it was kind of narrow this stuff down and put parents' minds at ease. But I mean, certainly every parent wants to start watching their child at that point. You're not going to say, Jimmy, were you molested at school today? But you certainly have the right to then start looking at your kid and say, well, gosh, wait a minute, I did notice something today, and so I'm going to be more on alert. And I'm just not comfortable without this bill that the folks who are in charge of this are paying enough attention to my kid. You know, I realize that they're often looking at the specific victim himself or even the alleged abuser. And I think parents have a right to just know this information. It's serious stuff, child abuse. So I think this is a good bill.
You're asking, did we?
No, he's asking if you can.
I want to put the amendment on there, which is putting the language from my bill, Senate Bill 145 on it. Yeah, make motion favorable. The one I described, the statute of limitations one we passed unanimously. I just want to put that on here.
All right, well, we're not going to move the bill without the chairman, but
right.
if you want to move the
I want to
amendment,
move the amendment, and then when he comes back, we can move the bill.
okay. Any objections to putting on Senator Huff's amendment? Take your time.
Senate Bill 145, the one we already moved, which just says the statute of limitations for if you interfere with or prevent the reporting of a mandatory reporter, that instead of a 3-year statute of limitations criminally, there is no statute. So you can come back if somebody, if you. Right now, there's currently a 3-year. We already passed this bill unanimously. Right now, there's a 3-year statute of limitations. This would go to no statute for criminal. It doesn't. So yeah, for prosecution. Yeah. This is criminal. It doesn't get in the civil bill.
So any objections to the amendment? All right, the amendment is adopted. Why doesn't everyone take a quick 5 minutes, and then we'll return here and vote on this bill.
Sorry. Let me know when you're ready. All right. I move favorable on that bill.
Second.
House Bill 931.
930.
House bill.
Favorable with amendments.
No cross-file, passed House unanimously.
Yep, everyone's good. Is everyone good?
Yes.
Okay, unanimous. Great. All right, we've got a couple more bills that are
Yeah. House Bill 104.
House Bill 104.
Oh, no, that was.
Huh? That
Sorry,
was.
I told it's a hold. We're waiting for the House is amending it.
Oh, got it.
What else? The other one, is the other one held as well?
House Bill 356 is a Josh bill.
Which one is it?
356.
356?
Delegate Chief. Corporations and Associations.
House Bill 356 requires the State Department of Assessments and Taxation by January 1, 2022, to review the filing fees and associated requirements of neighboring states that are equivalent or similar to filing fees in Maryland, and report recommendations to the General Assembly to make Maryland more competitive with neighboring states, including on whether to establish less frequent filing requirements, decrease fees, or establish a sliding fee scale. This is House Bill 356.
All right, everyone's fine with that. Okay, great. So I think that's, is that on, was that on the list?
It was on a previous list. House Bill 110.
I thought did we do that?
Hold on.
On 110.
Yeah, it's House Bill 110 is favorable with amendments by JPR.
Yeah, we voted it out.
We did, okay.
Yeah, yeah. Yeah, and then I want to do Sidnor. You had 271, which is not in your packet.
House Bill 271?
Yeah. Do you know what the bill is, Senator Sidnor? Or we'll put it on the next list.
Okay, that's fine.
Okay, we'll put it on the next list. Senator Hedelman.
House Bill 193 is a direct crossfile to something I think we passed, I think unanimously, and
It's a,
Yes, that's my delegate's bill.
right.
Yeah, but I think it was either not unanimous or if there was a change.
Yes, right.
So,
it was unanimous actually.
oh, wait,
Yeah.
no, we already, 193?
Yeah,
We passed that.
we did.
Yeah.
Okay.
It's on the floor.
Okay, I didn't see. Okay, thank you.
House Bill 193, favorable
Yeah, yeah.
report by JPR, yep.
Okay, great, thank you. Thank you, I missed that then.
Yep.
Apologize.
Yep.
No, we're not done, we have two concerns that.
Those are going to be. All right, so we're adjourning for today, for the floor. We're adjourned.